My name is Paul Diller. If you weren't here earlier, I'm a professor of law here at Willamette University College of Law in Salem, Oregon, where I have the privilege of teaching property most years. So that connects me to this subject as well as state and local government law. And I'm very excited to introduce our next panel, uh, which is entitled Panel on the Future of Residential Land Use Regulations. And I'll briefly introduce our speakers in the order in which they'll be speaking. First, we have John Nolan, Distinguished Professor of Law at the Elisabeth Haub School of Law, if I pronounced that correctly, at Pace University. Pace is in White Plains, New York. John is joining us from Tarrytown, New York, nearby. After Professor Nolan, we will have Professor Sarah Adams-Schoen from the University of Oregon School of Law, and she's joining us from Eugene. And third, last but not least, is Dwight Merriam, joining us from right outside of Hartford, Connecticut. And FAICP, if you don't know, is the College of Fellows of the American Institute of Certified Planners. And Dwight also was, as he was just sharing with us, if you weren't on on the site earlier, a lawyer for over 40 years in the land use space. So it's my great pleasure to introduce our panelists. Each will speak for about 15 minutes, and then we'll shift to Q&A. There is a place for you to type questions in the Q&A that you can see on the bottom of your screen, and I will monitor that. If you are another panelist who spoke at a different time, you can write in the chat and I'll also monitor that. So with no further ado, let me hand it over to John Nolan.
That's my last slide. If I speak quickly enough, I'll be able to tell a joke. So I'd like to start by thanking Mark and his crew for their persistence and their creativity in pulling this conference off. It's great. And to the extent that there are students on this program, I'm very pleased, because what I'm going to be talking about doesn't require you to lobby Congress or write to the state legislature, but you can get off your chair and go down to City Hall and start asking for more affordable housing. And let me explain how that works. The title of this panel is The Future of Residential Land Use and Land Use Regulations. And one might question why we have to deal with that. What has changed? What are the problems that require us to rethink our land use systems? And I have a group of students, 30 in all, that are working with me this semester, finding what local governments are doing with respect to their land use law reform with regard to what I call the three pandemics: COVID-19, the legacy of redlining or systemic racism, and the consequences of climate change. These are all things that people are now very concerned about because of the consequences of all three. They're right in front of our faces, and we're rethinking a lot, including our land use regulations at the local level. And then today we take on what I would call a fourth pandemic, the national housing crisis. The number of homes for sale has dropped by over 50% in the last 5 years. There are more homeless than homes for sale in the market in March of 2021. There's been a steady decline in homes for sale and production of new housing since the recession, the Great Recession. There's been a precipitous decline during the COVID-19 pandemic, but it accelerates in the previous decline, and the housing market needs to be fixed. My takeaway today is there are no silver bullets. So for those of you who want to lobby Congress and the state legislature, good luck in finding a silver bullet, but I don't think you're going to do that. So we have to choose our targets, we have to set our priorities, and we have to do what's feasible, in my humble opinion. I wanted to check to be sure that I wasn't reading national statistics and ignoring the Northwest, but the more I got into the housing crisis in the Northwest, the more I realized that it is a pandemic there as well. And I'll save you the details, but this is just some of the material that I found. You have a housing crisis and it's very acute. So there's a lot we could do to deal with the housing crisis. One thing is to get more housing, more market rate high-end housing, let them build all the single family housing they can, or get market rate middle income housing or workforce housing for the workforce. But I think that most of us, with regard to the consequences of climate change and the distribution of the contagion of the coronavirus, and of course, with respect to systemic racism, we're concerned with, and our target is affordable housing for low income, very low income, and extremely low income households. So one would think, and I believe there's a conversation about this earlier, that the Fair Housing Act would deal with some of these problems, and there might be a silver bullet there. And we were very pleased because of the ICP case, we call it, which held that disparate impact was a test for the violation of the Fair Housing Act, but it came with severe limitations. The ICP case, Kennedy wrote the opinion, and he talked about disparate impact claims cannot be based on one-time actions, that claimants must objectively demonstrate causation between alleged policies and outcomes at the pleading stage. Legitimate governmental purposes for a policy can defeat claims of discrimination, and I think ICP is generally regarded as having made it difficult for plaintiffs to win. And that's true if you look at the cases since the case was decided in 2015. So the likelihood of successful fair housing attacks on single family zoning, I think itself, are very slim. And just look at the second bullet. Defendant municipalities can explain a valid public interest served by single family only zones, and they'll point to property values, the cost of infrastructure, the cost of educating children, traffic, parking, environmental impacts of denser housing, etc. And they'll claim that this shows that the challenge practices serve substantial, legitimate, and non-discriminatory interests. So it's very important that we think about less discriminatory techniques that plaintiffs could come up with. My guess is, I don't have any data on this, but every time I check this in an individual community, there's always 60% to 90% of the whole environment. The whole environment is zoned single family housing. The landscape is zoned primarily for single family housing. So we've got the ability to adopt additional dwelling unit legislation in single family zones. We have the ability to allow single family zoning to include 2s and 3s and quadruplexes, even small garden apartments. And so these would be techniques that plaintiffs could argue local governments could adopt. But my big problem with these techniques is that I'm not sure they're going to discriminate less, because it puts the occupancy decision in the hands of primarily Caucasian people, who are the owners disproportionately of single family housing. And there are other poison pills, they call them, that are associated with the ADU movement and the missing middle movement, which have to do with cost, financing, tax treatment, design, and NIMBYism. So let's talk about something else. Let's talk about inclusionary affordable housing. And I wanted to spend just a minute on the difference between that and exclusionary zoning. Exclusionary zoning, which has been found in a few states by the highest courts of those states, says that under our Berenson case in New York, for example, the constitutional syllogism was, look, you get your power under our Constitution from the legislature, which can adopt police power regulations to protect the people of the state. And therefore, you can't use that to exclude large percentages of people of the state. So your power to zone comes with the obligation for it not to be exclusionary. Now, the definition of what is exclusionary zoning in almost every state, with a few a few good exceptions, is very, very general and hard to pin down. But it's more than zoning for multifamily. It is multifamily housing, that's non-exclusionary to the point, but it's also a lot of other techniques. And I have a checklist that I'll put up at the end of this presentation on a checklist of best practices for inclusionary zoning. Now, mandatory affordable housing zoning is probably the strategy of choice if you look at the literature and the practice. The question is it legal? And the California Supreme Court said it was in 2016. the city of San Jose had applied their mandatory affordable housing requirements to developments of 20 units or less, 15% of those units needed to be affordable. They could be put on site, off site. There could be a payment in lieu of a donation of land someplace else for the rehab of affordable housing in some other place. And it perpetuated the affordable housing requirements by deed restrictions. And the court held this ordinance, Supreme Court of California, highest court of California, said that this ordinance does not affect an exaction. Rather, it's an example of a municipality's permissible regulation of the use of the land under its broad police powers, just like a setback requirement or a height requirement. Is simply a limitation on the use, a requirement on the use of the land. So I picked another example of an affordable housing ordinance that I particularly like. It ironically comes from Garden City, which is arguably one of the most segregated communities in the nation. And under that local law, every development of 5 units or larger has to have 10% affordable housing. But for that, they get a 10% density bonus. And it requires that the affordable housing units be equally distributed among low income, very low income, and extremely low income people, which is really important because those extremely low income people have incomes below 30% of area median income, and they're the ones that are becoming homeless as the housing market tightens. The units have to be comparable to market rate in the same building, and it's deed restricted in perpetuity, and that is adopted on the books in Garden City. If you'd like to see the ordinance, just ask me by email and I'll send it to you.
5 minutes, John.
Thank you. So here's some additional best practices: flexible, larger scale, multifamily zoning, determining density by floor area ratio, not dwelling units, allowing conversion of unused offices, and malls, compact. You can read the list. And then here's some more. I can come back to these later. So I want to end with the role of the comprehensive plan, which is Ed Sullivan's unique field of practice. He knows more about it than any of us. But we all know that zoning has to conform to the comprehensive plan. So what we put in the comprehensive plan with respect to equity, with respect to COVID, climate change, or housing is going to dictate to a degree what zoning can do and what zoning should do in that local government. But it's very difficult to figure out when to amend the comprehensive plan, how comprehensively to amend the comprehensive plan, and what specifically to do. So we have these 4 pandemics. A lot of people are concerned about each of them. Some are concerned about all. And we should begin to do education, and we should begin to use our leadership and our advocacy at the local level to deal with these desperate needs. There are perturbations all over the place. We know there are problems, but what problems are we prepared to tackle? And we have many, many, many best practices. My students are coming in every day with more and more best practices to deal with COVID, climate change, systemic racism, and importantly for today, the national housing crisis. So the other day, Sarah and I were on Zoom with Dwight, and he was just regaling us and cracking us up with putting these various animations on his body. And at one point I took this snapshot of how he looked once he got done animating himself. He looks like a pirate, doesn't he? He's got a wooden leg, and he's got a hook, and he's got a sword there. And I'm going to end with the story of the pirate and the seagull. This pirate walks into the bar, and the bartender says, "Hey, mate, what happened to you?" And the pirate says, "Fine, I'm fine. I'm here to have a drink." And the bartender says, "No, look at you. You got a hook on your hand, and you got a wooden leg. And what happened?" And he said, "Well, I was out on the ship one day, and I accidentally fell off, and a shark chopped off my hand. But they gave me this hook, and it works great. And then another day, we were out in the ship on the deck, and we had to fight with these other pirates, and they lopped off my leg, and they gave me a really nice wooden leg here. It works great." And the bartender said, "Well, what about the patch?" And the pirate said, "Well, I was out on the deck of the ship one balmy day, and I was looking up into the sky, and a seagull pooed in my eye." And the bartender says, "No, seagull who would not put out your eye. And the pirate said, "You don't understand, mate. It was me first day with the hook." So we do a lot of training of local officials, and one of the things we train them to do is to think about what their local perturbations are, what people are concerned about, and pick a few tools to go home with and not end up lopping off their body parts. So one of the things we can do is walk down to City Hall, understand what we're advocating for in the housing space, and pick any one of a number of best practices, which we can talk about later, and advocate for those. Thank you very much.
Thank you, John, for a fascinating talk. As I think about it, one of the, I guess, pleasant ironies of Willamette law is that we're actually closer to the state capitol than to City Hall. We may be one of the only law schools in the country with that advantage. Of course, right now everyone's remote, so things are different. And now it's my pleasure to hand the floor over to Professor Sarah Adams-Schoen.
Hello, and thank you, and thank you. It's great to follow on John's talk. Thank you for setting it up so nicely too. So I'm going to talk in particular about land use law and housing justice, and within that context, these are some of the things that I think are really important to discuss in terms of reforms. So one is reforming, restrictive residential zoning, exclusive residential zoning, and zoning that causes a lot of harms. So I'm just going to call that restrictive residential zoning, R1 for short. But what I'm really talking about there is single family residential zoning, one home limited to one family unit, usually living in it on a relatively large lot as compared to how land is used elsewhere, for example, in other countries. So that's one, ending covert regulation of land users. And I'll get into that in some detail too. And then integrating environmental and climate justice into land use and zoning. I've also put up on this slide, although I'm not going to be able to talk about all of these things today, integrating anti-displacement strategies into planning and regulations, and reforming, really deeply reforming the public participation processes that happen with respect to planning and zoning. So I'm going to focus on the first three today, with no, I want to just caveat that the last two are just as important and just as related, but I've got my time constraint. Hopefully we can get to them a bit in the Q&A. So starting with reform of R1. So, one of the things that I really focus on when I'm talking about this topic is the, what were the values in the United States at the time that zoning emerged and proliferated in this country. And, zoning was kind of coming into its own right around the time that we had the Buchanan versus Worley decision from the US Supreme Court, which had struck down as unconstitutional a race, an expressly racial segregationist ordinance in Louisville. And those ordinances had been proliferating at the time. Often it's said that they were something that was happening in the South, although I would point out that California and San Francisco really had the first race segregation ordinances that were targeting Chinese immigrants at the time in particular. But something that's really important in this area to remember is that what was valued at that time was not equality and equity as we think of it now, but instead a separate but equal approach to the races, and really a white supremacist approach as well. That segregation and racial segregation were valued as in the public interest at this time, by people in power, white people in power, at the local, state, and federal level. So that's the context in which American zoning in particular emerged and proliferated. And so what we get is post-Buchanan, an approach to zoning that's really uniquely American. This approach includes, in particular, and this is the uniquely American aspect, the R1 district, the single family residential district, that's exclusive and that is cost prohibitive and uses economics as a proxy for race. And this slide is really just illustrating the point I was just making about what were the values of the people in power at the time that zoning, was emerging and being adopted. And so City of Portland has a great report on the historical context of racist planning in Portland. And as the slide shows, this is a picture, right? So the first zoning code was adopted in Portland, I think in 1920. And this is a picture right here of members of the Ku Klux Klan with Portland Mayor George Baker, Portland Police Chief Leon Jenkins, and the U.S. Attorney at the time, Lester Humphrey, in 1921. So one of the things that I like to kind of raise the attention about is that many of the expressly segregationist and racist tools that were emerging in the first half of the 20th century, despite their effects still being, felt, the tool themselves, like the redlining or, expressly whites only provision of quality public housing, those have been, deemed to be not acceptable or unlawful. But this tool that went right along with them, this single family exclusive and restrictive residential zone, hadn't, it kind of morphed in the public mind to be separate and distinct from these racial segregationist tools, and something that is in the public interest still today, and really continued to proliferate. And it typifies U.S. municipalities, really everywhere. And like I say, this really is distinct from zoning in other countries. So, and I posit the reason that the U.S. has this distinct R1 feature is that zoning emerged in the U.S. during this context where people in power were avowedly and expressly white supremacists and racial segregationists. So what is the effect of all this? Well, the effect is that even in places where housing is scarce and there are many people who are unhoused or who lack adequate and affordable housing, R1 zones make up a large portion of the land area in these cities. And so this is just showing Chicago, but I could pick on almost any city in the US. So in addition, tied to that is not only do we have this restrictive zoning, but often it's restricted to occupation by a single narrowly defined family. That also that limitation also has a disparate impact on communities of color and other historically and currently marginalized communities. So with that, I want to slide into talking about ending covert regulation of land users, because I think the two topics go together well, right? So here we have this historical context in which this R1 zoning arose. Well, zoning is based on this premise that compatible, harmonious land uses should be clustered together, and incompatible, inharmonious land uses should be separated. And the key there is uses, not users, right? So one of the things we see as we go back through, the sparse U.S. Supreme Court jurisprudence on zoning, and then at the state and local level, is and I should also just point out too, and in the records of so many municipal decisions, not historically but currently, this express desire and express purpose of protecting this R1 zone from uses that threaten compatibility as a place for families, right? And so we see references to the need to protect the peace and quiet, to protect the air quality, access to sun, access to nature, protect them against crime. And then we see that, the other side of that is the clustering, often in smaller land areas, of what are considered undesirable land uses, and with that is the equating of multifamily residential land uses with the nuisances or the undesirable land uses, as if the multifamily residences aren't, homes to families. So I said a minute ago, looking that we need to identify and remove these covert regulations of land users. I would say here that, anytime we start to talk about the R1 zone as a place for kind of families and the need to keep it residential, it's not really very covert that we're engaging in dehumanization of the people who live in multifamily homes. So, this equation with the nuisance and with the undesirable land uses, is really clear and expressed in the seminal Euclid versus Ambler realty decision, where the courts, equated multifamily residences to like mere parasites that in a residential neighborhood come very near to being nuisances, right? They're pigs in the parlor. These, always putting that emphasis on the use, right? Not the user, right? That the multifamily use is like this. Separation of residential business, which would include the multifamily and industrial land uses, promotes the public welfare, right? Why? Because it preserves that residential character of neighborhoods as a desirability as a place of detached residences. So one of the things I want to push on here is, what are we accepting kind of in terms of myths, potential, veiled racist, myths as well. When we're classifying something as a more intense land use that's incompatible with another land use, and really, if we strip that aside, are we actually trying to, regulate land users? And I would say it's actually pretty obvious that that's what the law does much of the time. So I ask here, I put a bunch of these slides here of some residences. Which of these are single family? Which of them are more intense land uses? So those are the two single family, and maybe you think that, maybe someone looking at this slide might think that some of these others look more intense, maybe not. But I would say, okay, so which also are the more intense land uses? And, maybe this triplex here, an argument could be made it's a more intense land use. I don't know, but, based on what assumptions? And so one of the things that I am really pushing for in reform is to scrutinize those assumptions, right? So identify regulatory requirements that raise the cost of housing or limit the development of multifamily housing, right? So any regulatory requirement that raises the cost of housing, any regulatory requirement that limits development of housing for multifamily, and then critically examine the assumptions that underlie how that regulatory requirement is for the public good. And by critical examination, I mean data too, data-driven examination. If you look at the data, people who reside in multifamily housing, including duplex and triplex, own fewer cars, for example. So, by critically examining the assumption that we need parking, the same amount of parking spaces per unit for a multifamily versus single family, we find that we don't. And then, if it's unclear, err on the side of equity. So build into our regulatory examinations and a requirement that we err on the side of equity when there's ambiguity. So some of the other things that we can do, right, in recognizing this cumulative and ongoing harm to Black, Indigenous, and other people of color, as well as other traditionally and currently marginalized communities, the harm from the American land use system, recognizing that harm and then taking affirmative steps to reform land use laws that perpetuate these harms. And here are just some ideas, right? So like I've been talking about, seeking out and eliminating covert regulation of land users, right? So important. Identifying impediments for fair and affordable housing, and critically examining the assumptions and erring on the side of equity, replacing neighborhood character and residential character. Right? We all know that these kinds of subjective requirements are, subject to so much mischief, and in particular with the neighborhood and residential character, the person, we don't have enough participation by the community as a whole in these land use decision-making processes. But if you're sitting there in the room and you grew up or you live in this in a multifamily district, and you're hearing your municipal officials talk about preserving the residential or neighborhood character of an R1 area, the dehumanization and the failure to see you as a person, and as a person who lives in a neighborhood also, is just clear. So that deterioration of trust is so problematic. So, replacing these kind of standards with objective, non-discriminatory standards, removing occupancy limits based on familial relationships entirely, what really is the public purpose served by having 6 people who are related versus 6 people who are not related live in a home? And then protecting and preserving. So we have this history of protecting and preserving the R1, protecting and preserving the multifamily areas against land uses that are incompatible with residential areas. And things we can do there are, start to, zone out uses that are incompatible and consider how the non-conforming use provisions are structured so as to protect and preserve these multifamily areas. So in terms of environmental and climate, so environmental justice, talking too about trust and this long period of trust, and I'm going to go a couple minutes over my allotted 15, but I think my co-panelists will forgive me, right? So environmental justice is tied, it's tied to this question of the future of residential zoning. They're fully integrated. What I have here on this slide is this picture depicting, or it's really illustrative, of the first Black community neighborhood in the Eugene area, which developed outside the boundaries of the municipality because of racist restrictions with regard to the development in the municipality. It wasn't served by municipal services as a result, but it still in its own way thrived, and approximately 100 people were living there, I understand, until the city of Eugene decided that it wanted to incorporate this area. The people were given some limited notice, and then the bulldozers showed up, and many people were able to only take what they could carry. And the people were redirected, this Black community, to live in, at the time, an undesirable part of the city, which is in West Eugene. And I have this here showing that all of this dark purple is heavy industrial. So probably it should come as no surprise that the zip code that represents this West Eugene area, has, the worst pollution in the city. And in fact, it has between 99.9 and 100% of total emissions, right? So, really, a stark and terrible example of environmental justice. So, speaking also of climate as a form of environmental justice, this is a historic photo showing the flooding of the Vanport area, Vanport in that used to exist next to Portland, Oregon, which was also a historic Black community. Not surprisingly, because it's so common, located in an area subject to significant flooding. This is a picture out of Arkansas, showing the 1927 flood, the Great Flood. This flood was devastating. The vast majority of people who died in the flood were Black. The other vulnerable populations as well. This is statistics following the fire season of 2015, or I'm sorry, of 2020, this most recent one. And this is estimating elderly excess deaths per million people, and this massive spike for Portland, which, if Salem and Eugene were on here too, we'd see that massive spike there too. So as we're doing climate adaptation, where are we doing those investments? Smoke shelters or flood mitigation. Who is benefiting from those investments? So this too requires a careful look at disaggregated data and data that looks at race and other race-based and other socially vulnerable communities, right? So proximity to noxious uses, access to healthy, culturally appropriate food, access to schools, access to open space, access to healthcare. But these are all things that need to be considered in zoning and other land use decision-making, right? Rezoning, variance, conditional use, non-conforming use, plan development approvals, not just in the area where the historically marginalized or currently marginalized communities live, but in other areas as well, asking, does this decision continue to perpetuate the disparate impact in terms of environmental harm, including climate, right? So lots of opportunity in land use decision-making. Who has access to mobility resources that actually reduce vehicle miles traveled, right? That actually get you to school or to the grocery store or to your job. Are we just requiring the new development include bike paths? Or are we looking at existing urban cores? And I know I'm talking about money when I say this because, the cost of a bike path can be put on the developer for new development. So it's money matters, but, right, we have a double win in terms of climate if we're putting these mobility resources in areas where people can really use them to get to essential services or destinations like jobs and schools. And so really with that, I'm just going to say, let's also though not forget that as we're looking at all of these things, especially as we're making investment in historically underserved communities, that we have to also be thinking about doing no harm or at least reducing harm. And one of the things that comes immediately to mind is gentrification. So with that, I'm going to skip through these slides because I know I've gone over, and just say thank you.
Thank you, Sarah. Excellent. And I see we're getting some questions in the Q&A, and please keep those coming. And now let's hand it over to Dwight Merriam.
Well, hello, here I am. Let's see if I can share screen properly here. How about this one? Am I on? And rock and roll. All right, thank you, Paul. Well, I'm thrilled to have been invited not only to participate in this symposium generally, but let me reset my timer here so that, Paul, you don't have to wrestle me to the ground. But I'm also very pleased to be on this panel. And what I'm going to talk about here is based on my experience long-term. I've worked on these issues for my whole career. My first book in 1984 was Inclusionary Zoning Moves Downtown, catchy title, a tribute to Paul Davidoff and his work. So now, from my perspective as someone still involved in it, but with looking back over all the problems we've had, I want to just highlight 4 things that I think some people have missed. And this seems like the wrong way to end the session before we turn to Kate Walsh for her closing remarks, but it's really a call to action of things we have to look at, we have to recognize, we have to be able to do. I understand a good percentage of you are students, and of course we have practicing lawyers and planners, and you students in particular, but also the planners and lawyers. If you want to write and publish on any of these issues, I would be very pleased to work with you on doing that. So if any of this gets your attention, get a hold of me and let's talk about how we can work together to help more people understand what's happening here. So with that, we have to orchestrate techniques. We have to do dozens of things at once if we're going to overcome the social, economic, and racial inequities that we still have and face going forward. And in doing that, in the case of Bridge Aina Leal against the Hawaii Land Use Commission, we just called it. Oh no, it has a a recording in the background. God, I hope that doesn't come up. So the first one that I want to talk about is the home rule myth, which is a view that home rule trumps all. And local governments keep putting forward the home rule argument. Chief Justice Marshall back in 1824 described the police powers, quote, that immense mass of legislation which embraces everything within the territory of a state, not surrendered by the general public. It is a state power. And as such, the community character argument is often put forward as well, that it allows some towns to maintain their character strictly by controlling multifamily housing. This is a comment of Bill Collins, the former mayor of Norwalk, Connecticut. And the defenders of home rule say things like this. They invoke character as a way to stop affordable housing. Here's a resident of Fairfield County, Fairfield, Connecticut, arguing against the state taking a greater role in controlling local land use. So what are we to do with this issue of the shibboleth of home rule? First of all, we got to take back pieces of it. Interesting conversations about California yesterday and the ADUs, and what the California Assembly had to do after their initial legislation with ADUs is they found out that many municipalities, not all, but many, were invoking lot coverage, setbacks, and other impediments, roadblocks to ADU. So they went back and they amended the legislation as a legislature. And we have to think about taking back the community character argument if you have it in your state. I'm not talking about Washington, Oregon, California alone, but the whole country. And here's an example from early in my experience in Connecticut when I moved here in 1975 to go to law school. In my neighborhood where I bought a house, they were prohibiting a half a dozen developmentally, intellectually disabled adults from living in a group home together. And the state legislature said, no, we can't have that. So they took back that little piece of the enabling statute and they amended the zoning enabling law to have this provision, overriding and creating a local definition that 6 or fewer persons are going to be treated as a family. It's that taking back of the power that's inherent in the state, because the police power is a state power that we need to invoke. And we are doing it across the country, but local governments sometimes don't realize it. So one of the things that we can also do is educate. I call your attention and ask you to go see the website, Desegregate Connecticut. This is an atlas. This is the town where I happen to live. Suburban town, 25 square miles, 25,000 people, something like that. And I live on a single family detached lot, 1 acre in a clustered subdivision. But here on the left from this atlas, go see this atlas. You'll learn a lot of what's going on at the local level, and you'll begin to appreciate more why the state and the regional planning agencies have to take greater control over local regulation. This is the town on the left. The purple is the area of the town which is exclusively 1 family, 1 acre or larger. What does that tell us? It's exclusionary. We're one of the most segregated states in the country. Now look at the one on the right. The one on the right is how much of my town of Simsbury allows 4 family or larger buildings on any size lot? And the answer is practically none of it. That little purple spot, a couple of purple spots. So go look at this atlas. It's really cutting edge. It's astonishing how much it'll convince people that they have to get out of the local control home rule regime. And commissioner training. We've heard a couple of panels talk about this in the last 2 days and how important that is to educate local officials. New York, at least states listed here, all require training of planning and zoning board members. They're mostly lay people. There's some of them here today participating with us. And thank you for, raise your hand if you're a local, thank you for raising your hand on that. If you're a local person on a commissioner or board, that wants to know more. And we need to help educate those folks who are trying to do their job best. They may not be professional planners or lawyers, but they're the decision makers at the local level. And training will help get them out of this home rule gridlock. And community character, I come back to this. What we're doing here in Connecticut is proposing that we change the enabling statute to limit community character, which has been an excuse for exclusion in some places, to just architectural consistency and population density. And then this, there's a takeaway here for all of us. The statute now that I'm circling here is very typical. Shall be made with reasonable consideration of the character of district, so forth, suitability. That is proposed to be gone. Take it out and substitute instead, and we're going to talk about this next, affirmatively furthering the purposes of the Fair Housing Act. This is a state enabling legislation change to overcome the home rule gridlock that prevents us from doing more affordable housing and breaking through the inequities of social and economic and racial justice. So, but then again, we flip back here, and here's the organization that represents most of the local land use authorities in Connecticut in one way or another. Here's their public statement. In the opinion of the Federation, it would take away the authority for local zoners, and they're fighting it. So we have that inertia. Second one, Fair Housing Act. I have written a lot on accessory dwelling units. I'm working in several different places developing their regulations. I'm a proponent. It's one tool that we can use. But you know what? The FHA has this Mrs. Murphy exemption that a lot of people don't realize that allows discrimination to go forward. So what do? Zoning is a state power. So go to the state statutes. Oregon has a very progressive inclusionary statute, but it still has, as you see here, just by way of example, some vestiges. Let me back up here. It must be an automatic event. Still has some vestiges allowing local property owners to exclude. And that's a political consideration for sure. But even the progressive states need to take a good look at what they're doing with regard to their own state laws of fair housing. I love this program, the Policies for Surveillance Program. I invite you to go take a look at it. It tells what all the states are doing, shows you how much they can do. And finally, think local. You don't have to wait for the federal government to act. You don't have to wait for the state to act. You can do it at the local level. That's what we're doing now in Connecticut. We've got this litigation ongoing in federal fair housing. We've got the Desegregate Connecticut legislative initiatives, and at the same time, we're going forward at the local level, developing regulations to make them more inclusive, and as a consequence, we're going to get some action done, I think. Private covenants, number 3. Now, of course, the racial covenants are unenforceable, but it's not the racial covenants that I'm concerned about now, except getting them out of the chain of title. And I'm working on some initiatives here to not only file declarations on the chain of title that says we don't accept these unenforceable restrictions, but we actually need to have a mechanism for removing the language so that when a title searcher does a title report, she or he won't have to reiterate that offensive language of racial and other exclusion. So take a look at what's going on at the state level. I'll give you some references there. But this one here, the many enforceable covenants preclude affordable housing. 7 million people in this country, 7 million live in gated communities. 61% of new dwellings have covenants. My house I happened to build 22 years ago. It turns out that there's a covenant that says it always has to be single family. And my neighbors could enforce it against me. How do I get rid of that? Well, Bob Ellickson at Yale has some good ideas that are here, and you can get them right on SSRN, pull them down. But we've got to figure out a way to overcome those otherwise enforceable covenants. And here's the Boston zoning code. I just thought I'd find you an example from somewhere. And here's Boston's. When they zone, they can't zone to impair any other covenants, deeds, or private agreements. We can't live with that in the long run if we're going to have a more diverse and inclusive community at the local level. So you can amend the statutes. I'll be interested in hearing our folks from Washington educate me more about Viking properties, a case in which the court said that they couldn't set aside a density restriction even though it was conflicted with the Growth Management Act because it didn't rise to that level of creating, quote, an evil. And even cited in a couple of later decisions and narrowed to some extent. It's still out there. So what do we do about cases like Viking properties? Well, we do have now already just about everywhere, like a note down here, just an example from Cape Cod, where review of a zoning proposal includes review of covenants. So we ought to at least be reviewing them before we grant zoning. But we need to remove them. And we had some discussion yesterday morning about retroactive application of notions of removing these otherwise enforceable covenants dealing with multiple units and so forth. I think one way to approach it is something I've developed in connection with low-level radioactive waste siting and reflecting on the Iowa right to farm case where it was set aside, the right to farm was set aside as imposing a negative easement on the surrounding properties. If you want to take away the single family covenants and so forth in order to press for more units, you're going to be taking away a private property interest. And we ought to be able to set up a regime whereby we can announce that we're going to set aside those covenants and people can apply locally through an adjudicatory proceeding to be paid for the value lost in releasing that covenant. And those values will be small or non-existent. So we're not talking about a lot of money. You might even have to use the eminent domain power, but you could, to take those covenants, use money from a trust fund, from impact fees and the like to fund the trust fund. But it can be done, but I'm afraid that we're not quite there when it comes to retroactive application of releasing those otherwise enforceable covenants. My last piece here with a minute or so to go is something that practically nobody I've found even know exists, but it's terrible. And that is, in some jurisdictions, the resale restrictions include a restriction on selling price based on the monthly carry, how much it costs to own the house. And if that monthly carry includes mortgage interest, someone who buys an affordable unit, you ready for this? You won't believe this. Somebody who buys an affordable unit when interest rates are historically low, like now, could end up in a situation where interest rates rise, the monthly carry rises. Once the monthly carry rises, the sale price has to go down in order for the affordable family to be able to afford it at the percentage of their disposable income that's allowed under your statute. And that property owner, I have determined, the one who bought during a low interest rate time, can lose all of their down payment and still be underwater and obligated to pay more. That's just not right. So if you go back and look at what they do in Maryland, they've got a better way of doing it. But just be very careful of this on your resale restrictions, that you don't set up a situation where you include mortgage interest rates that then results in a loss to the property owner. And here are all you need to know from Maryland. So there we go, done. We need to move forward to clear the roadblocks so that we can put into action all the good ideas we've heard here the last 2 days. Thank you for your attention.
Great, thanks. And we have about 35 minutes for some questions and answers and discussion among ourselves. Let me get to a question that's been queued up in the chat for a little bit from Anyele Halova, who spoke yesterday. And I think Sarah indicated interest in answering this. Do you have any specific advice to give Oregon's Department of Land Conservation and Development or individual cities in Oregon to address the issues specifically discussed in your presentation? What's going well and what needs further attention?
Well, yes, and one thing I want to do, and I know Commissioner Halova addressed this a bit yesterday, is that so Oregon currently has, the Department of Land Conservation and Development currently has a rulemaking advisory committee convening to implement portions of the governor's executive order on climate change. And so some of this work is already being done as part of that committee's charge, but there's more that needs to be done, and state law change would help as well. But one thing, really to just be specific is, I had some slides up of flooding, for example, and so flood, as well as all natural disasters and climate-related disasters, disparately impact the very low income and Black and other communities of color, and renters, and there's all sorts of problems. And Oregon, like so many states, sets the standard for flood resilience at the standard set by the federal minimum floodplain regulations. And those regulations don't actually create flood resilient communities. They create, to the extent they're successful, flood resilient buildings. So that is just one point, and I only make the one, but I could make it for other disasters as well. But those regulations are focused on, I call, the building scale resilience. They are not focused on community scale resilience. And in fact, they don't even comply with the National Flood Insurance Act's mandate to move development away from flood hazards, because they actually allow for and facilitate development in the most hazardous flood areas, as long as the building incorporates certain standards like elevation that keep the building safe during flood. So as a result, all this development has occurred, and it continues to occur in flood risk areas. So I'm just talking climate adaptation right here. So Oregon follows that standard and has seen that kind of development, especially with respect to riverine development. And many communities are at a lot of risk as a result of this, and the most vulnerable within those communities are at the highest risk. So there's that. I just also want to just briefly plug the climate mitigation. It's not just adaptation that needs to consider housing and justice. Climate mitigation, which is really the focus of the current rulemaking committee in Oregon, that's the reduction of the greenhouse gas emissions and the increase of the carbon sinks. One just specific thing that we all can do, and this applies nationwide, is when we are setting benchmarks or standards that we're measuring against, like, for example, standards that measure how we're going to reduce vehicle miles traveled. If you look at standards, you'll often see things like the addition of a certain, how many miles of bike path were added, how many miles of safe bike paths were added, without looking at where they were added. And because of the way, amenities like that get funded under local, in local jurisdictions, those amenities are usually being added where there's new development on the periphery. And often they don't even get people to the core or to where they might have to work. And so one of the things we can do right away is look at the data, who has access, and tie that data to social and, to social vulnerability and other vulnerabilities. Who has access to what we're requiring to be built, to meet certain benchmarks, the bike path, and are we only focusing on, for example, an electric vehicle, which might be priced out, is priced out of a lot of markets, and not maybe thinking of micro-mobility. So there's things that can be done like that. I know in Oregon, we're thinking about that right now already. And of course, there are more. So those are some of the kinds of things I'm talking about, like really look at adaptation carefully, and the vulnerability of our most vulnerable communities. And when we do mitigation, where are we making these infrastructure investments to really benefit those who have, just throughout the history of land use law in America, right? Modern land use law in America have been over and over again, oppressed by the system and divested of their wealth by the system, not included in the system. Like my kind of push here is there has been so much harm. We must always err on the side of equity at this point, and we have to keep it front and center as we develop new tools like tools for climate mitigation and adaptation.
So I see Chris Elmendorf has emerged, and we're happy to see him again. He was a speaker yesterday, professor at UC Davis Law. Chris had a couple of questions in the chat that I don't know if everybody out of the audience can see. Chris, why don't you ask your first one, and then the second one actually merges, or the question you had for Dwight merges nicely with one that is in the Q&A. So, but why don't you ask the first one first?
So my first question was for Sarah, and it was about racial equity analysis as a mandate under state environmental review statutes, or maybe an independent racial equity review statute. So the New York courts, I believe, require a racial equity or gentrification analysis where that's arguably relevant to a project under SECRA, which is the New York mini NEPA statute. There was a recent decision from the California courts rejecting that approach under the California environmental review statute known as CEQA. San Diego at the city level requires a racial equity analysis as part of its review process. And so I wanted to know whether you see this as like a positive development where it's happening, or something that we should be concerned that might be turned into a tool for blocking housing, raising the cost of housing in the same way that project level review under environmental statutes has become, certainly in California, maybe elsewhere, a tool for both homeowner opposition to be manifested and for labor unions to raise the cost of construction by insisting on prevailing wage agreements as the price of dropping their CEQA suit.
I'm going to answer really briefly, and then I think John Nolan, in New York, can really speak to some of these questions about environmental review because of New York SECRA and just the amount of focus you've given to that material, John, and those But what I want to say is, I'm really concerned about it as a tool of the NIMBYs. And the raising of the costs, which is just contrary to getting more housing on the ground. I want there to be a mandated review of data, but I think that my personal feeling is that some of the review and standards can come from the state. The state can help identify certain things that are always or almost always creating these barriers to just housing and standard. And we see that in Oregon. We saw that in Oregon with the middle housing law, and we've got legislation up now that's further diving into these questions like, parking and, maximum densities and, prohibitions or limitations on manufactured housing, difficulties with dividing properties. So some of that can just come from the state and then apply to all projects. But I want to pass the question also to John Nolan.
Thank you, Sarah. The definition of environment under the State Environmental Quality Review Act in New York is very broad, and it includes change in community character and population distribution. The village of Portchester just recently amended its zoning ordinance completely and decided to call on seeker to do an analysis of displacement of legacy businesses because they were concerned about all the Latino businesses being displaced because of the commercial redevelopment that would be authorized under the new zoning. And they put that in their generic environmental impact statement. They committed themselves to doing everything they can to prevent the eviction of commercial tenants. And that's one of the pluses of this law in the state of New York. I think, Chris, if there were a court case that had mandated racial equity analysis in the secret process, I would know about it. I bet that there's a appellate division case someplace that maybe said it was okay, like what Portchester did, to do that type of thing. But I don't think the state would add to the statute. But what happened with climate change about 10 years ago was very instructive because the staff of the DEC did one of the most amazing jobs of outlining the criteria for environmental impact statements with respect to climate change, and went through this long list of all of the things that could increase emissions and all the things that could be done to mitigate those impacts. We could do the same thing administratively through rulemaking in New York with regard to your question, but I believe it would take state legislative requirement to make it mandatory. The other thing I wanted to point out is that, and I'm delighted to know what you said about San Diego, because we just found Montgomery County, Maryland had adopted a racial impact analysis for any zoning text amendment. And these are the things that are percolating up. These are perturbations at the local level. People are very upset in many, many places about our systemic racism, and they're coming up with local techniques. So anything we can do, Chris, if you know more about those kinds of racial equity analyses, I'm going to be writing on that. I'd love to know.
So Chris also had a question directed toward Dwight about covenants, asking why compensate anybody for the removal of covenants when I suppose another way to do it would be to take some action in the courts to have a court declare them outdated under the third restatement. And we had a question from Will Curran Groom asking why, I think what he's trying to ask is why the ability to regulate private covenants is exempted from the municipal police power, given the relationship between the two. So Dwight, would you like to answer those?
No. Yeah, of course I will. And we have a brain trust here of other people. We got Ed, Jennifer, Robert, and Chris himself. I knew that when I suggested compensation for the retroactive termination of covenants, it would be like poking a stick in a beehive. But I did it for practical reasons. First of all, in Washington, if Viking, given the way Viking was decided, if it can't happen in Washington, it's not going to happen in 40 other states that are less progressive than Washington, Oregon, California, and the like. So as a practical matter, it will take us a very long time with a whole lot of expensive litigation to move 50 states in the right direction in terms of their state law, okay? And as a practical matter, the value of those covenants removed, for example, single family covenants, is going to be minuscule or non-existent. And if we can do it at a adjudicatory level, then the states that are very conservative and pro-property rights oriented are more likely to get on board with the possibility of some partial compensation without having to litigate them in most cases. If you make that a step proceeding to litigating the takings part of it or the eminent domain part of it, then you'd be way ahead of the game. So it's really a practical orientation. Yes, in Viking, for example, the court said, look, get the legislature to say that it's a critical public policy issue and they support it. And then we might decide otherwise. So we'd have to get all the legislatures to decide that, say, single family covenants are a critical public policy issue and should not be enforced. So then there we go.
Dwight, can I just follow up? Why do you think the value would likely be minuscule? I mean, I could see some homeowners hiring an expert who says, wow, the value of my single family home in this exclusively single family home neighborhood will be reduced by half.
They'd need an appraiser that follows the very strict rules of appraisal today to say that. And just based on my experience, I happen to be a counsel of real estate. I wrote the valuation chapter most recently of Nichols. So I do a lot of evaluation, eminent domain work. And we find that these claims are really way overblown as to what the impact is of taking away some of these minor private property interests. The fact is, in areas where we know that there are illegal ADUs, some of them, half of the ADUs are illegal, the people love them because they add value to their property. They've now got a new income stream. So I think it would be small, and it would be a fraction of what it would cost to litigate that. And as I go back to the beginning, my last point is my first point. We need to move. And one way to move it is simply say, you think you're hurt? Bring an appraisal in. We'll pay you some money out of a trust fund. We'll make those building new houses chip in the money, because it's the benefit of the entire community.
I just want to jump on that too. There's a lot of people who say that they're going to be harmed by a lessening of the restrictions, the single family, low density residential restrictions. But a lot of people are harmed by their, by their existence. And not just the people who are in multifamily, but the people who are in the single family themselves, right? Those who want to age in place, and so they want to convert the upstairs to an apartment, right? Those who suddenly they've got their college kids home living with them because of a pandemic, or all sorts of different things that are, their flexibility in the use of their property is constrained, right? An interesting thing has occurred over time here, is that we saw, right, this, going all the way back to Euclid, right, and a pro-private property conservative justice writing an opinion, and going also back to Buchanan versus Warley, right, an opinion about about the right to use our property as we see fit. Yet in America, in the United States, we accept this incredibly restrictive local regulation on property use, and we call it good for those who are restricted, right? And so that there is one of those assumptions that really I think needs challenging. I live in a single family home, and it's bigger than my family needs. Maybe I get laid off during a pandemic, or during, what's going on, and I could just convert the downstairs to a duplex and get some income from that. So these restrictions can be harmful for all. I actually threw up on the shared screen a provision from Oregon's middle housing bill from 2019 that's now law, and how it's dealing with these restrictions in the record title. So it's unclear from the law itself whether or not it's whether it's forward-looking only or retroactive. I would have read it as retroactive, but it's being interpreted as not retroactive. So I was just sharing that for folks who are interested.
Well, I'll just interject here. Robert Liberty asked him to just open up his video and jump in, but he says, to me, you may be interested in the experience Portland, Oregon had in promising to pay homeowners for any reduction in value caused by the construction of an aerial tram to the Oregon Health Services University. No takers. All right.
Interesting.
Chris, you're right. As a professor, you're right. As a practical guy in the trenches every day, I just want to see it done. So.
Okay, great. Yeah, we have some more questions in the chat and in the Q&A. I had a question for Dwight with respect to calling home rule a shibboleth. Those, for some people, are fighting words, and in some other ways, home rule can promote affordable housing or inclusive zoning. You have several states where state preemption limits the ability of local governments to provide or zone for more affordable housing, like banning inclusionary zoning. banning rent control at the local level. So is there a way to kind of redraw home rule to get the good without the bad, at least when it comes to housing?
Well, my only point was that I don't even dare, talking to a local zoning authority, tell them that it's really not their power. It's the police power. It belongs to the state. And they only get to act because the state gave it to them. I stopped driving my car to hearings because my license plate number is zoning, because you know, they go after my car. So what I'm saying is we need to educate the local decision makers that their range of power comes from the state, and they ought to be working with the state in terms of that power, exactly as you suggest, Paul. That they need to use the home rule like we're doing when we're developing ADU regulations across the state, but they shouldn't be using home rule to throw up a thing like community character, which is the worst thing ever. There's just end of single family zoning. I do not like that term at all. It's not the end of single family zoning. It's the opening of new diversity and inclusion. And so when they say we can't stop single family zoning because it will ruin our community character, and that's in some of the enabling statutes like ours. We need to go back, pull out of the enabling legislation the excuses that people use for being exclusive.
John?
I just finished an article about a year ago on home rule and Dillon's rule. And thanks to my students, we were able to dig into all 50 states. And what I learned from them, not being a home rule expert, other than in New York, is that there are a variety of forms of home rule. Almost every home rule statute is different. Many of the constitutions of the states are different. It's very difficult to generalize about home rule. People use Dillon's rule quite often to say we have limited power at the local level. In 40 states, we found specific revocations of Dillon's rule, either in constitutions or state statutes or the courts. And the takeaway, without going on and on about this, which I'd love to, but without doing that, the takeaway is that local governments have tremendous flexibility with the absence of Dillon's rule and their home rule and their constitutionally delegated authorities through the state legislature to do land use, which is very plenary in most states. They can do almost anything they want to do the kinds of things that Sarah is talking about. And all the different techniques that I put on that slide at the end of my presentation. I couldn't agree more with Dwight, however, that local governments have to reach out to and cooperate with their states for a whole bunch of reasons. And yet I still think that if you are an advocate and you're a practitioner and you represent real estate or a land use or an environmental interest, you can go to the local city hall and get almost anything done that you want if you do it correctly. At least the legal power is there, and we have best practices to offer people to suggest that other people have done it and been reelected.
Yeah, and I think a lot of these points hit on what was Sarah's fifth point, which I know she didn't get to in depth today, but I think really could be where some of the action is in the future, and that is public participation. Sarah Schindler of Denver and Kellen Zale of Houston wrote a great brief paper that I heard them present last fall about how a lot of cities and states have laws that favor homeowners in public participation and other things. Like notice about new developments goes to homeowners and not tenants. If you think about local governments exercising zoning power on behalf of the state, you could argue notice ought to go to everybody in the whole state, or to residents of a low-income community nearby because they're affected by a zoning hearing in a higher income suburb. So I think that's an area that is also ripe for reform. And I'll put that a citation to that or a link to that article in the chat. I see, Robert, you've had a question and a comment, so maybe just restate those for everyone to hear.
The comment is that it ought to be possible now to show what the effect is, at least on home prices, the introduction of additional housing types like accessory dwelling units or duplexes. I mean, it's hardly necessary to do this research because some of the highest value neighborhoods in the entire country are mixed use, mixed housing type. So it seems kind of silly that you have to go back and make this point. But if you wanted to make the argument at least about home prices, which people offer as an excuse for opposing these changes, that may not be the real reason, is it's possible to go back and look. There's a lot of places now that have had ADUs, a lot of ADUs added in California and Oregon. I know of several places and show there's been no effect on price, right? So that would be one little bit of factual research that I think could be helpful. My question for John and Dwight was, what's the effectiveness of YIMBY groups in the Northeast right now?
Well, I'll answer quickly because Dwight may know more than I, but in my radar that I use to track things, I haven't seen that acronym used in the Northeast very much, but we've been doing YIMBYism for years, knowing that decisions that are made about affordable housing at the local level need advocates there at those public hearings. So we have countless training programs and advocates and examples of people going to local board meetings and advocating for affordable housing as a method of kind of balancing the scales. So we've had YIMBY here, but not by that name. Dwight?
Well, I'll talk about New England just sort of generally. Vermont was one of the early states to allow ADUs as a matter of right throughout the state. That's Vermont, you know how they are. And, you know, it's not like we've seen in other parts of the country. It's not like we're seeing in Berkeley right now or Minneapolis, or we don't have that level. But we have this organization, Desegregate Connecticut, which is largely driven by Sarah Bronin originally, but a whole lot of people have joined on. And I really encourage our participants to go to that site, Desegregate Connecticut. You'll see a model for sensitizing people to how bad our existing zoning is. And I just end with this point, Robert, that, and I tried to say it at the beginning, we need to orchestrate approaches. So we have the litigation going on by Open Communities Alliance against the town of Woodbridge, Connecticut, to force them to allow multifamily units. And we have Desegregate Connecticut in the legislature trying to get them to make affirmative changes to our legislation, to take away roadblocks and to open up new paths. But both of those initiatives are going to take a long time with somewhat uncertain results. So at the same time, at the local level, we've been working with municipalities to develop pro bono services, to develop ADUs and other multifamily regulations at the local level. And just end with saying that the first town I've started that in, 5,000 people, and they really want to open the door. So it's really the grassroots, not the state level or even large city municipal level YIMBY movements that we've seen elsewhere, but it's each and every little town and village deciding that they want to do something. They're not going to wait till the federal litigation is over. They're not going to wait till our slow legislature acts, but they're going to start doing it at home.
So Dwight, we had a specific question in the chat, and to our attendees, you can see that some of us have been trying to type answers to your questions as they come up. Hopefully those are helpful. But one question for Dwight, or that hits on Dwight's comments, is from Catherine Daniel. Does you see it? Okay.
Yeah, so
go ahead.
Her question is, does our 830G is our zoning override statute? It's like Massachusetts, Chapter 40B. You want to do an affordable housing project, zoning authorities say we don't want that, you get to sue and you get a leg up. Some of them, one of them cases has been going on for 15 years without resolution. They're very expensive, they're very time consuming, they're large, well-heeled developers for the most part. So it's helpful, but it's not the end all. The question was, have we taken the initiative to get the formula changed? And the answer is, as soon as this call is over, I'm going to make some calls, because we haven't done it. And it's by state regulations, not by state statute. So we can fix that formula. It's just that nobody's paid attention to it because interest rates have been so low for so long that they haven't suffered the explosion that will occur when interest rates run up. So thank you for the prompt. We had to prioritize. We're in triage when it comes to affordable housing. We've got to go forward with the most important things first, and the formula is important. I just wanted to alert people, take a look at your formula and take a look at how Maryland does it, which protects the property owner, shares the equity. Don't use a formula like we have in Connecticut, because I think it's fraught with problems.
Sarah wanted to comment on public participation, and maybe Sarah, while you have the floor, one thing I didn't see on your list of barriers to more inclusive zoning that is a favorite bête noire of some people who promote inclusionary zoning is historical preservation. So maybe you could also address that and your views on that as a legitimate or maybe not so legitimate concern.
Well, so the first thing I want to talk about is participation, like you said, and I think it's in some ways it's key to it all, right? We have to for one acknowledge the white dominance of the land use field, which is true of so many fields, right? But as we're talking about solutions to a housing justice crisis, we can't, there's so many potential pitfalls, right? White savior kind of syndrome, and so some things that we can do there, right? Well, one is just be aware, right? Do some work on learning about what are characteristics of white privilege and white supremacy, just so that if you're inadvertently promoting those features that make the conversation more open only to white participants, but also so for public participation, one of the things that I've heard from people, and it's even resulted in proposed legislation in Oregon, is that the pandemic, by requiring public meetings to be accessible online, has allowed people who couldn't historically participate to participate. You can participate online without having to provide your name and show your ID, which can be very threatening to groups who are fearing fearful of the government for one reason or another. Those who are working a job and parenting, maybe doing so single or even not, right? Taking that time to get physically to and from the meeting can be, make it so that it's not available to them. They're, often scheduled when you're putting your, child to bed, things like that, right? So one plus there is, let's continue to make these meetings accessible to people, and I don't want to say it's a panacea, right? A lot of people don't have access to that internet availability either, but it's one potential. I also can note that in Minneapolis, leading up to the Minneapolis 2040 plan, Minneapolis used a lot of really innovative public participation methods, holding meetings and public forums at street fairs and different places where people gathered back in the old days when we were allowed to gather without risk of, dying or spreading a lethal virus, right? But, so involving the public, but then another point that I think is so important is to consider when the public is involved, and not just the public, I shouldn't be saying that, but, I'm talking about the communities most affected by housing injustice, right? So Black, Indigenous, and other communities that have historically and currently been suffering the most from these injustices. Are they involved at the decision making at each point in the decision making, right? So from inception to review and revision, right? As you're setting standards, as you're making goals, and creating, removing barriers and attempting to create pipelines to leadership too, right? So I just can't overemphasize that enough. When people ask, like, where are some of these ideas coming from, this integration of climate justice and housing justice ideas and land use, they're coming from, community organizations, that are led by the affected communities So, you know, they're already there, they're already doing the work. And to that, I would add they're also doing too much of the work. And so we also need to, when we're paying for experts, we need to pay for the expertise of lived experience expertise, you know, at that point in the process when we pay for experts. But
So
I can
let me
recommend,
just, oh, I'm sorry.
I just want to plug NAACP for its work and Beyond Toxics, and I plugged some other groups yesterday.
Yeah, we may not have time to get that. Thank you. We can just leave historical preservation for another time. That's fine. I kind of dropped a big topic with just a couple minutes left. We do have another speaker scheduled for 11:45, so I want to make sure we stay on track, and that is Kate Waltz. And I believe, Sarah, you'll be introducing her. So let me just say before we do that, thank you to our panelists. Thank you, Dwight. Thank you, John. Thank you, Sarah. This was excellent.
The invite.